What's up everybody, welcome to Money Management channel. My name is Andrei and today I'm gonna be doing an update on MMTLP and FINRA saga.
I got the cash in the bag, stadium packed. Born a rock star in this life, gonna live it up.
And guys, for today's video I have basically just two news, but these news are extremely important for MMTLP community. Unfortunately, one of them is not the best one, but the second one is much more promising. And before we dive deep into all of this, guys, please hit the like button for YouTube algorithm and drop me a line in the comment section if you think my videos are valuable for you. On top of that, guys, at the very end of this video, I will tell you my personal story. That is why please watch this video till the very end, because it is very important for me personally. So, and let's begin today's video with the good news. Let me show you several tweets that were published by Scott Roth, and first of all, I want to begin with this one. He reposted the tweet that was written by John Reed Stark, and John Reed Stark wrote this. Expect all SEC administrative law judges to be fired forthwith. And he added, in a letter filed in a case before the Third Circuit, DOJ wrote that the multiple layers of removal restrictions shielding ALJs violates the separation of powers doctrine. So the US will no longer defend ALJ's removal restrictions. Courts have already eroded SEC ALJ authority considerably, but this is the final nail in the coffin. And here is the letter itself. Let me quote you some details. We filed this letter to notify the court that the acting Solicitor General has decided that the multiple layers of removal restrictions for administrative law judges in 5 U.S.C. paragraph 7521 do not comport with the separation of powers and Article 2, and that the United States will no longer defend them in litigation. Accordingly, at the oral arguments scheduled for February the 20th, the government does not intend to press its merits defense of paragraph 7521, answering brief 4147. But the government continues to argue that petitioner must demonstrate compensable harm for an allegedly unconstitutional removal restriction, answering brief 4849, and the court can resolve petitioner's removal claim on that ground. And guys, it is quite interesting letter. And because of this letter, guys, Scott wrote this. US DOJ says securities judges are unconstitutionally protected by excessive bureaucracy and invoke the appointments clause. Trott versus Rubinstein adds it in as a judge race in deciding whether or not to allow yours truly to proceed with the US constitutional challenge to FINRA, torpedoes in the water, MMTLP people. And he added these screenshots, guys. He added also the letter that I just read to you, but let me quote you his own letter. So, a notice of supplemental authorities to the Honorable Court. Plaintiff Scott Roth respectfully submits this notice of supplemental authorities to bring to the court's attention newly relevant legal and factual developments regarding the constitutional validity of defendant Financial Industry Regulatory Authority. These developments have direct and material bearing on plaintiff's claims in his second amended complaint challenging FINRA's constitutionality, particularly under the Appointments Clause and separation of powers principles. Introduction. On February 11 of 2025, the United States Department of Justice filed a letter in Axalta Coating Systems versus FAA, notifying the court that the acting Solicitor General has determined that multiple layers of removal restrictions on administrative law judges violate the separation of powers doctrine and Article 2 of the US Constitution. Consequently, the United States will no longer defend these ALJs in litigation. This position aligns with plaintiff's argument that FINRA, as an entity exercising governmental regulatory power, is similarly unconstitutional due to its lack of accountability and multiple layers of insulation from executive control. Given that the DOJ has declined to defend ALJs under similar legal reasoning, FINRA's status as an unconstitutional SRO is further underscored. And he also added legal implications of the DOJ's position, but I want to pay attention to this part. FINRA's multiple layers of protection from executive control. The DOJ's stance in Excel accounting systems further highlights that quasi-governmental entities insulated from presidential control violate the Constitution. FINRA's leadership and oversight mechanisms present even greater constitutional deficiencies. And here are 3 bullet points. First one. FINRA's board is composed of unelected officials with rulemaking authority over securities markets, yet it lacks direct presidential oversight or removal power. Next one. FINRA enforces securities laws without being subject to removal by the president or any elected official, violating Article 2's vesting of executive power in the president. And third one, the SEC's oversight of FINRA is largely illusory, as FINRA acts independently while clocking itself as a private entity when convenient and as a regulator when challenged. Conclusion. The DOJ's decision not to defend ALJs under Axalta coating system solidifies that entities exercising regulatory power without presidential oversight violate the separation of powers doctrine. The same reasoning applies to FINRA, those whose existence as a privately controlled yet governmentally empowered entity raises serious constitutional concerns. Accordingly, Plaintiff respectfully requests that this court take judicial notice of these developments and permit all constitutional claims against FINRA and plaintiff's second amended complaint to proceed in full. Please see attached letter from the US DOJ. And guys, I have to admit, with the most recent news from presidential office and from Dodge, I have to admit that this letter has a tremendous power in it, and because of these guys, we might have a huge breakthrough in our case. And this is, in my opinion, the best news for today's video. The second news is not so perfect, I would say. The X-Market News wrote this report: SEC working for hedge funds, and it says the SEC failed to permit a private company's S1 to raise capital for 2 years. The SEC may be strategically stalling to weaken NBH financial, potentially forcing a sale or bankruptcy, protecting short sellers from scrutiny. And guys, let me show you this. I have to admit that for quite a long period of time we didn't have a lot of updates from MMTLP resources, but for now, guys, for today's video we have basically 2 of them. And one of them is this one. Next breach PR indicates SEC obstruction in S1 approval. Let me quote you some details. A press release from Next Breach Hydrocarbons discusses their extraordinary long and obstructed path to getting approval for their S1. In their second press release of the week, Next Breach reports they have received further feedback from the SEC on their January 2023 10K form. And here is the part of this PR statement. We are disappointed to announce receiving another round of SEC comments to our annual report on Form 10K for the 2023 fiscal year, the 2023 10K, which will further delay the effectiveness of our registration statement on Form S1 to offer to the public 40 million shares of common stock, the offering originally filed on January 23, 2023. And Crucial Mix also added this. This delay causes hardship for the company's planned public offering of 40 million shares of common stock. The company has spent 2 years attempting to file an effective registration statement to secure capital, but it seems the SEC is intentionally delaying approval, potentially harming the business. The hedge funds and brokers would love nothing more than Next Breach to file bankruptcy, alleviating them from their open short positions left in the MMTLP stock. The SEC is now asking Next Breach to alter its accounting practices in relation to the company's corporate history. That's been asked for of Next Breach appears to us as unreasonable. Chairman and CEO Greg McCabe stated, "As in the past, Next Breach will continue to advance our business strategies on the oil and gas front, while concurrently investigating the magnitude of our demonstrable shareholder imbalance. In light of recent events, the company will pivot and intensify our efforts to obtain clarity on this untenable and inexcusable imbalance, which remains to this day an unsettled injustice to our loyal shareholders. And guys, here is this press release. It is quite long press release, I would say, but let me show you the summary of this press release that was made by ChatGPT. The NextBridge Hydrocarbons announced further delays in its public stock offering due to ongoing SEC comments on its 2023 financial statements. The SEC disputes how the company impaired the value of its Orogrande property, requiring extensive restatements in past financial reports. These changes could take months and cost hundreds of thousands of dollars. The company proposed simpler alternatives, but the SEC rejected them, insisting on restating financials. Additionally, the SEC challenges how NextBridge accounted for its history during a merger and spin-out process, which the company strongly opposes. Due to these regulatory challenges, NextBridge has paused several major projects, including the Louisiana Heritage Plate transaction and other negotiations. This delay also affects resolving shareholder imbalances, including $2.65 million unsettled trades acknowledged by FINRA. Chairman and CEO Greg McCabe reaffirmed the company's commitment to its oil and gas projects and resolving shareholder injustice while addressing these regulatory challenges. All SEC communications will soon be available on the company's website for transparency. And guys, I have to admit that we have two pretty much opposite points of view, and I want to read both of them. And you have to make your own conclusion about this. So this tweet was written by Marituvito Saletant, and it was reposted by John Burda. Let me quote you this in details. So I placed the NBH PR into an AI model to see what it returned. The following is the result: MMTLP. The SEC is blocking NBH's ability to raise capital. Without the S1 approval, NBH cannot sell 40 million shares to raise funds, putting financial strain on the company. This limits NBH's ability to develop assets, pay legal fees, or fight back against regulatory roadblocks. The SEC may be strategically stalling to weaken NBH financially, potentially forcing a sale or bankruptcy that would further protect short sellers from scrutiny. The SEC is likely aiming to limit NBH's corporate viability. Even if NBH doesn't plan to trade publicly, the mere ability to raise capital could make it a stronger company, which is what the SEC may be trying to prevent. If NBH remains cash-strapped, it becomes easier to bury the MMTLP issue and avoid exposure of fraudulent naked shorting. Institutional players with short exposure to MMTLP and Torchlight may be lobbying the SEC to keep NBH in a financial stranglehold. The SEC's position on the Orogrande asset devaluation is a delaying tactic. The SEC is deliberately creating an accounting roadblock, insisting that NBH restates financials. This forces NBH to go back and amend past reports, delaying the S1 processes months or years. This means NBH can't access new capital anytime soon, which may force them into desperate financial decisions. 4. The SEC's stance on Torchlight MMAT merger could be to shield institutions from MMTLP fallout. The SEC is trying to reframe the corporate history of NBH by treating the 2021-2022 period as a custodial phase rather than a legitimate corporate transition. This could be a legal maneuver to weaken potential claims from MMTLP shareholders, making it harder for them to argue that MMTLP was wrongfully handled. The goal might be to eliminate NBH as a vehicle for exposing financial fraud from the MMTLP situation. And 5. A clear message. The SEC does not want NBH to succeed. If this was a routine review, the SEC would allow the S1 to proceed while addressing any minor issues through standard compliance measures. Instead, they are blocking NBH's ability to function by dragging out financial restatements for years. This suggests that powerful interests do not want NBH to raise capital, grow, or become financially stable. Bottom line, The SEC's motives are highly suspicious. Rather than focusing on investor protection, the SEC's actions appear to be a deliberate stall tactic too. 1. Block NBH from raising capital. 2. Weaken NBH financially to force unfavorable outcomes. 3. Reduce legal liability for institutions that were involved in MMTLP. Next one, ensure NBH never has enough financial power to challenge the system. The key question: if NBH is simply trying to sell shares and raise funds, why is the SEC so intent on delaying this process? And guys, I have to admit that this entire statement makes a lot of sense, but let me show you completely opposite opinion. Trader Zero wrote this and Samantha reposted it. I mean, really, you all didn't think McCabe was gonna ride off into the sunset with all the booty, did ya? LOL. This is the part in Scooby-Doo when they rip off the mask and it is the old man all along. The timing of this is good because I was thinking about this asset grab scheme tonight anyway. Before that, I want to address McCabe's inaction to get real answers versus this dog and pony showable BS. Oh, Cowboy knew about this SEC's response before there was Christian PR on February 18th based on his description of events. He has the nets to pump you with the West Christian PR 2 effing plus years later and right before dropping a bomb on Friday. And guys, this statement also makes a lot of sense. Look, if McCabe truly believed there was illegal crap going on, he would do what anyone running a business would do, and it's not bringing out the law firm of smoke and mirrors to so-called investigate on Tuesday, then bury the bad news until today. All that crap is giving the illusion that hiring Christian was a proactive instead of reactive. His whinny comment about how the SEC is calling him out on standard accounting practices is going to slow down his efforts to go after the shorts is straight up dirty. What a F you to shareholders. I'm going to tell you what he could have done about the halt, shorts, and why he didn't. I will show you why this isn't the SEC overstepping to hurt NBH. It's standard accounting, and it's evidence of a bigger issue that goes all the way back to pre-merger. Pizza first, stay tuned. So guys, I have to admit this opinion also makes a lot of sense, and it is up to you to decide which one is the real one and what was the real intention of SEC and Greg McCabe in this saga. But at the same time, guys, I still have a lot of questions that are unanswered, and these questions should be answered by the C-level executives, and Greg McCabe is definitely one of them.
And guys, let me tell you my personal story. I have a wife and 2 children aged 11 and 15, as well as a small dog. After 30 years of living in Russia near the Baikal Lake, we decided to move. Now we reside in Serbia. Although I don't own any MMTLP shares, I invest a lot of time creating daily MMTLP videos. I have been doing this every day without days off and holidays for more than 1.5 years. Now I wish to buy back this time from my family, from my children. We've agreed that I will ask the MMTLP community to support me, and I will give all the money to the children. Therefore, if you believe that I am providing useful content for you and wish to support me, you can join my Patreon account. For $5 a month, I will add your name to my list of supporters if you wish. Thank you in advance. The link you can find in the description below. So, I think that's all information that I want to provide you. If you like my video, please hit the like button and subscribe to my channel, and see you guys and girls next time. Bye!
I got the cash in the bag, stadium packed, born a rock star.